Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon, everyone, and welcome to Business Legal Lifecycle TV. Today is Wednesday, so it's a longer form education show, and today we're talking about protecting intellectual property. I'm here, Craig Mason, also with me, Jeremy Stretton. Say hello to everyone, Jeremy.
Hello, everyone. Hope you're having an awesome day.
So, as I said, today we're going to talk about protecting intellectual property, which is a pretty important phase of your business. You've obviously developed products or services or whatever it might be, and now you need to go about protecting that intellectual property. So, Jeremy, do you want to explain a little bit more about how this phase fits into the life cycle?
Yeah, sure. Thanks, Craig. So for those of you who are watching us on the various platforms, Facebook, YouTube, or Twitter Periscope, you'll see that I've brought up a picture of the business legal lifecycle. You may have seen this before. If you're listening to us on the podcast, please don't do it while you're driving. If you're driving or if you're at the gym, when you got a chance, go to businesslegallifecycle.com.au. And if you have a look at the homepage there's a picture of the business legal lifecycle. You could also check out the videos on Facebook or YouTube. So if you go to businesslegallifecycle.com.au/126, you'll see links to all that. But with the show, with the people who can see it, the business legal lifecycle is 13 phases of when you should take certain legal steps in your business. So phase 5 is protecting intellectual property. And as Craig said before, this is done really after you know that you've got a product, you know that you've got something that's worthwhile protecting. So the advice from a lot of lawyers is let's protect your intellectual property early on. And what we've found is, whilst that's great, most businesses these days can start, up with an idea, an internet connection, and a web page. That's all it takes, in 2018 when we're recording this, to start a website, to start a business, I should say. And so you need to be able to protect yourself and your business, but you don't need to spend the money early on because it is a costly process. So we've put phase 5 after the first 4 phases, which are all the startup phases, which is starting up your business, coming up with your idea. It's engaging with your initial clients and bringing on your employees. Because what we have found in our research is that the businesses that do all that first and then protect their IP, one, they've got the money to do it, and two, they're not going to be making changes to their IP that they might make later on. So that's the reason for phase 5 being where it is. This month, September 2018, is all about protecting intellectual property. So we're going to be talking about that on our Fast Fix Monday shows. Today's show, education show about phase 5 protecting intellectual property. And next week, we're going to do our training show, going through a bit more of the specifics and nitty gritty of what you need to do to protect your IP. So there are basically 4 talking points that we're going to talk about today. I'm going to go through copyright. What is it? Go through some examples and how to protect it. Craig's then going to talk about trademarks and what to do there, what they are, how to protect them, different classes, all that kind of information. I'm then going to do asset protection and why that's important and how you do that. And then Craig's going to finish off and do license agreements. Craig, is there anything you wanted to add before I move into the first one, copyright?
No, I don't think so. Let's kick in with the content.
Sounds great. All right, so the first one, as I said, is what is copyright? Copyright is the ownership that you have in the expression of an idea. So this is a really important concept to understand. Copyright attaches automatically when you actually create something. So for instance, Craig and I have copyright in the video that we're creating now. It isn't the actual ideas that we're talking about in the show itself. Now, the distinction is a finite one, but it's one that's really important to understand. That we can copyright this actual show, or my book, The Business Legal Lifecycle, that can be copyrighted. But the actual ideas that we put in there aren't what's copyrighted, because it's the expression of the idea, not the idea itself. Now, that might seem like a technical distinction, and it is, and it's very important to understand. Now, copyright basically attaches to anything you create automatically. You actually don't have to do anything to create copyright or to enforce copyright. You can just claim it straight away. Often you might see the little C with the circle around it. I should do it the other way around so it's proper for the people viewing the video. You can put that on there, but even if you haven't, you've still got the protection. So the second slide on copyright is infringement. So as I said before, you can't infringe someone's copyright by having the same idea. So expressing the idea in a different form, that's fine, because that's not copyright infringement. Infringement of copyright would be taking this video and showing it on your own channel and branding it yourself, or getting my book or one of our articles and branding it with your own information. That's infringing copyright. As I said, you can't get copyright in an idea. You can only get copyright in the expression of that idea. So protection of copyright, as I said before, is it's something that you need to be wary of. To protect it, you need to go ahead and actually go and enforce your rights. So if you think someone's infringed your copyright, whether that's an article that they've posted online, whether that's a book that they've published, or whether it's something like this, a video, then you need to go and actually go to a lawyer and go and protect it, because that's the way that you protect it. There's no automatic protection. There's no government body that actually looks after these things. It's actually just something that you need to protect yourself. So copyright is it's one of those things that is often misunderstood. It's something that, as always, we're happy to help out and give advice on, because it is a simple thing that it does attach. But a lot of people do get confused and do think that copyright is something that might automatically attach to their business, or in some in the expression of their idea. And it's really important to understand that it's not the expression of the idea. It's the expression of the idea, not the idea itself. So that's copyright. Craig, do you want to go into the second one, trademark? So what is a trademark?
Yeah, absolutely. So your trademark's often called a brand. So it's essentially your identity. So it's the way you show your customers or the outside world who you are. It might be your corporate logo, a jingle that you use in an advertisement, or your business name that's painted on the side of your truck or van or whatever it might be. So your signage or your packaging. Trademark can also be a word, and that's in plain font or a fancy type font. It could be a phrase, the lettering, numbers, logos, pictures. It could be an aspect of your packaging, or it could be a combination of a number of those things that I've just mentioned. So it's quite broad in what a trademark can be. But essentially, when you're looking at it, it's your brand and how you are identified. So, in order different to copyright, was what Jeremy was talking about before, there is a registration process in order to register your trademark, which you will need to do in order to protect it. It's very important when we talk about it in Australia at the moment, that you need to register your trademarks, and I'll touch on international registration a little bit later in the show. So if you bring up the next slide there, Jeremy, the process, and this is the process of registration, which, as I said, is the most important part of it. Following the process, it can be, there's a few things that pop up along the way, and it can be quite a drawn-out process, so it's best to get advice about it. Talk to your advisors and make sure that you do it properly. There are costs involved, obviously. lodgement fees, etc., with IP Australia and the other various trademark registration places around the world. There'll be fees associated with it, so you want to get it right the first time, so you're not wasting fees. So obviously the process, you need to decide that you want to register the trademark and you've got something you can register. Understand the goods and services and the classes that you want to register in, and I'll go through the classes in a moment. Obviously you need to search to make sure there isn't anything out there that's similar. So IP Australia, for instance, you can search in there, searching for the particular things that you're thinking of trademarking, seeing if anything comes up that is similar, and then if there is something that's similar, then you need to seek some advice about whether or not that's going to be a problem. If there's nothing out there, then great. You can then proceed to make your application. In IP Australia, for instance, it goes through the registration section and is examined by IP Australia about your trademark. They will let you know if there's a problem and ask for you to make submissions. Obviously, the problems could be that there's something in it that can't be registered, or there's something that is similar that you didn't find, etc. So you want to make your submissions, again, seeking the advice of your advisors at that stage to make sure that you make the best submissions that you can. If all that is excellent and agreed after the submissions, then it is a registered trademark. Then it's advertised, and if there's no objections, then you have that trademark for 10 years. It's pretty important in the registration process to make sure your address is up to date in the registry, because they will send out notices along the way, or the renewal items. So make sure that your address is up to date. Also, one thing to bear in mind with trademark registration that we see quite a lot, scam letters that go out saying, you owe these fees, etc., that make it look like it's from IP Australia or some other entity. Most of the time it's not. So be careful with those sorts of letters and don't go paying things willy-nilly. Obviously, if you've had someone take care of the trademark for you, like a lawyer, then contact them, because they'll probably tell you, no, ignore that, because that's already been paid. So just a side note with that, I know that we get those on a regular basis, so make sure you're aware of that, and keep your address up to date so you're not missing out on anything along the way. You can change the address, those sorts of things, through the registry. It is sometimes difficult if you want to amend your trademark along the way and add different classes. You may need to make a whole new application in relation to that. So important to follow the process. Excuse me. As I said, the classes of things. So you need to have a look at the classes, the goods classes, and work out what class you want to register your trademark in. There are extra fees for each class that you want to register in. So I don't suggest anyone, and they wouldn't get away with it anyway, register in every single class just to cover everything. It costs quite a lot of money, and it'd be knocked back because you wouldn't have anything that's in those classes as well. So there's different classes. For instance, class 1 is chemicals used, or chemicals, science and photography, agriculture, horticulture, those sorts of things. Class 8, for instance, is hand tools and implements, cutlery, sidearms, razors. Class 12 is vehicles, and that's land, air, or water. Class 31 is raw and unprocessed agriculture, grains and seeds. And then there's some services classes, which are from 35 to 45. So class 43, for instance, is services for providing food and drink, and services for temporary accommodation. Class 44 is medical services, vet services, beauty care, etc. So important to look at the classes. They're not all self-explanatory, and they'll fit in nicely. For instance, services providing food and drink and temporary accommodation in class 43, you may not expect them to be necessarily together. So it's important to go through the classes and check it all out. And once you've got that and you know what you're going to be doing, so if it be frozen berries, for instance, and you're fitting into that class, or it could be fresh fruit and you're fitting into that class. So you've got to make sure that you've got the right class before you make the application. and then you'll go through the process, and hopefully it will be straightforward from there. Jeremy, is there anything you wanted to add with that part of trademarks?
No, I think that's a good summary of it. I mean, we're not going to go through all the classes, but we'll make sure we link in the show notes to the link where the classes are, and there's a class search tool that you can use as well, because what Craig's given you is just the quick brief summary of what the class actually encompasses, but often there are multiple things in the classes that you may not even think of. So yeah, no, I think that's a good summary of the process, Craig, and the classes.
Excellent. All right, so as I said earlier, I was just going to touch on international registration. So most of what I was talking about was the process in Australia. I presume most other places are similar in that way. But in terms of international registration, so an Australian trademark registered as per what we've been talking about provides protection only within Australia. So if you want international registration and protection, there's two ways an Australian trademark owner can seek trademark protection overseas. So that could be an actual application filed directly to each country. So you go through the process, similar to the Australia process, and do it in the particular countries that you want trademark protection. The other way is via a single international application, and that's filed through the World Intellectual Property Organization, and they nominate the Madrid Protocol countries in which protection is sought. So if you apply directly to another country, you need to do that through their system, obviously, and not through IP Australia. You'll need to, and it's separate applications. As always, we'd recommend that you seek advice from intellectual property professionals before you go filing individual applications or filing the single application through the World Intellectual Property Organization. It's not something that I'd suggest you go about doing by yourself. Whichever option you choose, obviously, you'll still end up with a separate trademark applications in each country. So if you want to do international registration, you need to go one of those two ways. Now, the Madrid Protocol, just quickly, so that's a treaty that provides international registration of a trademark. It's, as I said, administered by the World Intellectual Property Organization, and it facilitates trademark applications in a number of different countries. I'm not going to go through the list, but if you go to the website, there's a full list of the member countries that an international application can cover. So check that out if you're interested in that. In terms of the international applications, obviously you need to have an application or registration in your base. So in Australia, you must meet the entitlement requirements within Australia. The mark on the international application must be identical to that contained on your Australian application or registration of the particular good or service, which is important. So you can't change it just for international. The applicant on the international application must also be the same applicant that was on the Australian application. So a couple of things to bear in mind there. As I said, it's not an easy process, and I definitely was suggesting seeking the right advice when doing that. But as I said, you can register your trademark internationally if you go through those two channels. So that's international registration, Jeremy. If you want to go on to the next topic.
Thank you, Craig. Yeah, so I'll go on to asset protection for intellectual property. So this is something that's widely misunderstood and something that we just wanted to go through in a bit of detail, because if you've got certain assets, you might want to protect them. And if you've got a trading company, then it could be liable for certain debts and costs and all the rest of it. So you want to make sure that if you do have intellectual property that is worthwhile protecting, that you want to protect, that you look at one of these asset protection strategies. So before I talk about the actual strategy in itself, I just wanted to talk about liability in business. So we've talked before in other shows, especially when we've been doing phase 2, which we did in August 2017 and August 2018, that the liability of the business really comes down to what entity is actually trading the business. So if you've got a business, and we've used this example before, but I'll use it again. Fred's Widgets Proprietary Limited, it produces widgets of some kind. if it's just a proprietary limited company, then it owns the business and it is liable for all of the debts of the business. It's liable for any defects in the widgets that it produces. It's liable for any damage that's caused by those widgets. If depending on the liability, there's different avenues for that to occur. However, just bear in mind that it's liable for anything that the business is liable for. The company that runs the business is liable for in this instance. So if rather than Fred's Widgets Proprietary Limited, which is a separate company, you had Fred was actually running the business. Fred in his own name trading as Fred's Widgets without any company. Fred would be personally liable for that business and for any debts of that business, anything that went wrong with that business. So when we talk about liability in business, we're talking about the fact that that company, Fred's Widgets, or that person, Fred, is actually liable for all the debts of the business. That's a really important concept to understand, because in a trading business, lots of things can go wrong, depending on whether you're a lawyer, an accountant, a coach, you're running a 7-Eleven, whether you're whatever business that you're running, you could be liable for all manner of things. You've got the debts that the business incurs. You've got the liability for people that come onto your premises if you've got a premises. You've got liability for your employees if you've got them. You've got potentially professional indemnity insurance if you're or professional indemnity liability if you're running that business and you get sued, and you can get insurance for that. You can get product liability. So if you're producing widgets and those widgets, as I said before, have a problem, then you can be liable for the damage caused to someone else because of those widgets. So there's a concept of a separate holding entity that actually owns that the intellectual property behind the business. So for instance, if you've got intellectual property that, or an asset, even a property or anything, it should not be owned by the entity that trades the business. So I've got a slide up which shows Fred's Widgets Proprietary Limited, and we've got Fred's Holdings Proprietary Limited. If Fred's Widgets Proprietary Limited trades a business, owns all the intellectual property in the business, and say it owns the property from which the business operates, then Fred's Widgets Proprietary Limited can be liable for any of those things that I talked about before, and any of the assets that it owns can be attacked. So if it gets sued because something went wrong, then it could lose all of its intellectual property. It could lose all of its property assets because it owns everything. We see this time and time again. People just get their entity, whether it be their own name, or whether it be a company, or whether it be a trust, and everything's owned in the one entity. We talk about a company that just recently that we were advising on that was starting up a new breathing coaching business, and they had all these entities and all these businesses and all these assets owned by the same entity. That's a really dangerous idea, because if that entity gets sued, you could lose all of your intellectual property, all of your assets. That's why we recommend having a structure, and I've shown a very simple one on the slide here, where Fred's Holdings owns all the intellectual property and it licenses the use of that intellectual property, or leases the use of property or plant and equipment to the trading entity. That means that if Fred's Widgets got sued, and we don't want that to happen, but if it did, then all the intellectual property is still safe and held by Fred's Holdings, and you can change the trading entity to another entity. That's a perfectly legal way of operating your business. It's a perfectly legal way of having asset protection in your business. There's nothing wrong with that. It becomes problematic if you start setting up multiple trading entities, letting them falter, not paying your tax, and start phoenixing those entities. If you start making that your business model, that can be a problem. But if you've got property, if you've got intellectual property that needs to be protected, then this is a really good structure and quite legal and quite normal for you to set up to actually protect your assets. So Craig's going to talk about license agreements in a minute, and that's really the context that he's talking about it in. He's talking about in the sense of where intellectual property, so whether that be your ideas, if you've got a book, if you've got concepts like our business legal lifecycle, you should know that the business legal lifecycle isn't owned by our trading entity, because it's a separate legal entity. It's a separate concept that is owned by another entity, and that's just good asset protection. As I said, there's nothing wrong with it, but it's a really good way of actually structuring it. Craig, do you want to talk about anything on there, and then talk about license agreements?
Yeah, no, I'm happy to kick into license agreements.
Sounds
I
good.
didn't have anything else to say.
Cool.
Yeah. So license agreements in two contexts. One would be between what Jeremy's talking about with the separate holding entity and a license agreement between the entity that holds the intellectual property and the entity that's trading the business. So you would do a license agreement between those two entities. So a license agreement is essentially where you license your intellectual property. That gives the licensee the right to use that intellectual property, not to own the intellectual property, but use the intellectual property. So in the example of Fred's Widgets, the two companies, I can't remember which one it was, Fred's Holdings it would be, has the intellectual property, and they're licensing that to Fred's Widgets. So Fred's Widgets never owns it. They just get to use intellectual property in the business. So in that example, that'll be an exclusive license when it's between two related entities like that. If you were doing a license agreement to someone in the outside world, then you may have a different type of license agreement. There'd be certain things that you make sure that are in there. The term of the license agreement, what the exclusivity of it, is it sole exclusive or non-exclusive, those sorts of things, whether there's any fees associated with it, etc., for using it, whether any modifications can be made, etc. So if you're going to license it or even license it between your related entities, you should have a license agreement, and within that you're going to have certain terms that need to be followed to protect you as the licensor, and there'll also be things in there to protect the licensee as well, depending on the type of agreement between the parties. But if you're doing it internally, like the example in the slides, then we'd still suggest that you have a license agreement in writing that you talk to your lawyer about prior to doing it. And obviously you want to get your accountant involved as well when you're doing any asset protection strategies, such as the separate holding entity for the license agreement. So I think that's it, Jeremy. Unless you had anything else.
No, I think that's great. I think that's a good explanation. I hope everyone's got something out of today's show. As always, we're happy to answer questions, provide feedback. There's many ways to contact us. If you want to check out the show notes, go to businesslegallifecycle.com.au/126. We have a workbook for today's episode, which is posted on the Facebook link and will be posted on in the show notes as well. If you want to get in contact with us, you can email us at lifecycle@jeremystretton.com. You can comment on the Facebook post. You can jump onto YouTube and ask comments there, or even on Twitter. We're happy to answer any questions. We'll be back on Friday with our monthly legal updater for September 2018. Craig, is there anything else you wanted to say before we say goodbye?
No, I don't think so. Please, if you're interested, join us on Friday. We'll be going through a number of updates in the legal world over the last month or so. So look forward to you joining us then. See you later.
Thanks, everyone.